Everyone, this is Alan Cowell, and I am really delighted to have Mr. Ralph Sherman with me to do some very unique and special training on that was found on some research that he was doing for me. I hired Ralph. Ralph is an SEC attorney. I hired him many years ago to give me information about what what's going on in the industry when it comes to the SEC and how it relates to private lenders and what we can do to stay safe when working with private lenders. And Ralph has done an outstanding job at doing that. And along the way, he uncovered something that I think is just phenomenal. And I have asked him to spend some time and share that with you. And so, Ralph, are you out there?
I am, Alan.
Great. Well, I appreciate you being here, and I'm going to turn this over to you in just a second. The important thing here, folks, is you're going to grab a pad and a pen, and because you're going to want to take a lot of notes, because there is nobody else on the planet teaching this topic, and it is something that my students are using, and in fact, even students in Canada using this. So, Ralph, I'm going to turn it over to you, and let's go ahead and share with the folks what you found out there for me.
Well, I think what we've found, and it's both a law and a regulation, and it's absolutely 100% verified, SEC approved. It's a unique opportunity for your students in any country, in the United States, in any state. And it's true, I've already worked with some of your students up in Canada. It's an absolutely unique opportunity to raise money, up to $5 million, in fact, in the state of California, and take it out of the state if you want to, and absolutely you can use some or all of it in the state of California. And no other state has availed itself of this opportunity, but we're going to explain over the next little bit of time, step by step, what this is, how it works, how it's legal, what makes it legal, and how to utilize it to grow your real estate investing business.
Oh, that's awesome. Well, let's go ahead and get started then.
Well, I'd appreciate the opportunity. I do appreciate the opportunity to be speaking with you today, Alan. I'm going to do a little introduction. This is me a few years ago. One of the highlights, frankly, of my career, I was invited to become a member of the bar of the United States Supreme Court. So my wife and I went to Washington, D.C., and I joined a group of lawyers that I'm in a fraternity with, and I've been in a fraternity since my law school days in Boston. And we were ushered in. We actually had breakfast in the Supreme Court building. We were then brought in to the Supreme Court chamber, and individually the Chief Justice called us up, and we took the oath of office as members of the bar and became Supreme Court lawyers. And it's not my goal to have any of your students need my representation there, but it's more a matter of honor and privilege. Plus, I have the opportunity as an attorney to listen to any case I want to in person. If I show up, there's a special seating section just for Supreme Court lawyers, and I have the opportunity, if I wish to use the same law library the Supreme Court justices do. And that is something I do plan on using from time to time. But it was a wonderful day and a great memory. So that's my picture. And my credentials, just so people know, you've got an SEC attorney. I started practicing law in 1988 in Massachusetts, which is the state where I grew up. I later moved to and became a member of the bar in Michigan. So I'm a member of a number of federal district courts, appellate courts, as well as U.S. Supreme Court, and also the United States Tax Court. So my goal in getting to these credentials is simply to be able to demonstrate my capabilities, my education, my knowledge, but most of all, my ability to add value to clients and to help educate your students. And you're right, it's been close to a decade we've been working together, and it has been a great thrill for me to work with the entrepreneurs, your students, who are real estate investors. So this is a unique opportunity for them to learn about something that no one else is teaching. And frankly, the state of California has never spent money on this. They've never budgeted promotions of this. They simply look at it as a part of the law. And they're happy to have the business because they do make filing fees, and it does encourage people to do business in California. But it's a great opportunity for your students to take advantage of the law and to, frankly, have an edge on any of their competitors. So as you like to say, let's start at the beginning. You hired me to do research for all of the U.S. over some time and even do some research on the system of securities law, which is similar but not quite the same in Canada, not as a matter of giving legal advice. Just for example, doing this kind of talk we're doing isn't legal advice, but nonetheless it is legal research that I've conducted, and I'm telling you the facts of the case. We always encourage people to get their own professional advisors, whether it's an attorney or an accountant or someone else, but to let people know the facts and the opportunities. So this is a California-based opportunity, but every one of your students, wherever he or she is, who's listening to this, can avail him or herself of this opportunity. That means individuals, husband and wife, father and son, whatever the setup of your company is, whether it's one person or dozens, if you do the setup we're about to tell you and follow the laws and the regs, you could be raising up to $5 million a year in California and using it to grow your real estate investment empire. So here's the nutshell. And this is true. It is verified. $600 filing fee once a year, paid, and we'll explain even who you write the check to and what their address is, that kind of thing. You pay $600. You can raise $5 million. You can pool the money, and yes, you can advertise and take the money into your company and use it in the state of California, outside of the state of California, or both. That is something I want to emphasize. $600 filing fee gets you this chance to raise $5 million, pool, and advertise. So now, I want to make sure people understand what the opportunity is. You're going to be borrowing money from people who are generally called qualified purchasers. Now, this also includes the term that's used at the federal level called accredited investors. They must reside in the state of California, but you can use this money in your state and possibly other states. And you asked me to explain this to make sure I could answer this the correct way, and the answer is yes. You can take the money from California and put it to use. Now, you have to tell people what your plans are. You're going to be honest, as you always are, in disclosing what the benefits and the risks are. We're not guaranteed, but the point is, I can tell you for sure this opportunity is real and it's legal. This is called, and I want to read the full title to people from the state of California. Under the state of California, Business, Transportation, and Housing Agency, Department of Corporations, Limited Offering Exemption, Corporations Code Section 25102 sub N. What you refer to as, in shorthand, as the California loophole. We're going to be explaining this today to folks listening in. So what is this thing, this 25102N or California loophole? It can be a pot of gold. It really can be. There's an opportunity to raise up to $1 million if you're an LLC, or if you come in as a corporation, $5 million.
Oh, so they differentiate between the two.
Yes, they do, and it's simply because when this came into effect in the mid-1990s, it was in cooperation between the federal SEC and the state of California. Every other state in the country could then and still can technically choose, if they create the state regulations, they could have this too. No other state has chosen to do that. So right now, the only opportunity is in California, and it's been almost 20 years, actually, since California put this into place once the federal SEC said they could do so. So it's unlikely that you're going to find any other state making this available. So California really is, it's like another gold rush, in effect, because it's the only state where you can do this, Alan.
Do you have any clue, Ralph, on why California decided to up this? Because what you ran into in all the other states is there some...
And I truly believe this. My research indicates it. I've even talked to the Department of Corporations staff attorneys out there several times because you've asked me to be, and I like to be thorough in my research. California likes cutting edge. In fact, they went as a Department of Corporations. And by the way, that's the agency in California that is the state SEC or the SEC division. So they went to the federal SEC and said, we need a way to go above $1 million, because most states say the most you can raise is $1 million until you do a different kind or a special kind of filing that's much more involved and much more disclosure is required. And the federal SEC typically says to the states, you can't go above $1 million unless you file something with us. Mm-hmm. So they basically sparked it or ignited it and got the federal SEC to take comments, to do research. The SEC staff worked on it, and the SEC commissioners voted for it and said, okay, California, we like your idea. Here's what's going to be required. And they created something called Rule 1001 and put it into the federal regulations under the Securities Act of 1933, which has been amended numerous times since 1933. And they said, now, California, here are the things you're going to have to put in place. But since we don't do things for one state only, any other state that wants to copy this can do so. But California was very motivated in the early 90s to expand the opportunities to create business. And without making any political judgments, the people in government at that time saw an opportunity to spur entrepreneurism. And so technically, it's not just for real estate. This was also intended to help people raise money for high-tech companies. You could start a bakery or a pizza, but in other words, to create the opportunity to go above $1 million, they needed a special rule to make it easier for it to happen. So that's what California said we want to make happen. The SEC said, we'll go along with you. We'll open up the opportunity to every state in the country. Arizona actually looked at it and started, and then their legislature simply shut down and never picked it up again. So that's how we got to today's situation, where your students are now learning that the only state that allows it is California. And for the LLCs, you got to remember, 20 years ago, LLCs were much more rare than they are today. And so they never implemented a change that would say LLCs can raise $5 million. They specifically said corporations could. So that's how you end up with this quirk. So we want people to know, if you set up, whether in California or bring in your company from out of state and qualify to do business in California, if you go in as an LLC, you can only raise $1 million a year. If you go in as a corporation, you can raise $5 million a year. So I leave it to people who are listening to make the judgment. Do you want to go through this effort to raise just $1 million potentially, or $5 million? I'm not telling you what to do, but you can tell what your opportunities are, and you have a 5 times greater opportunity with a corporation than an LLC.
All right.
Now, you coined this term, Alan, and I commend you for it, because it makes it easier to say than what I said a few moments ago with the state name and the department name and then the limited offering name. You coined this term California loophole, and I don't want anyone to think that they're skirting the law or doing an end run. No, this is absolutely legal. And I'm working from paperwork that comes directly from the California Department of Corporations, because I've been spending my time the past 25 years telling people how to do things the right way, the correct way, within the regulations. And that's exactly what your students, anyone listening to this, can learn from. And you did it just so you could teach people about this and take advantage of it and have a leg up on their competitors and to grow their businesses.
Yep, that's true.
To become bigger and better investors if they choose to. And again, we have that pot of gold come up because, again, 1 million, 5 million, pooling money, advertising, keeping the money in the state, taking it out of the state. It's an absolutely fantastic and legal opportunity. Now, it does work with Regulation CE. So let me explain very quickly. We might even have some fellow lawyers listening in, or they might want to ask a lawyer about this. The Securities Act of 1933 was passed by Congress because the new president then, Roosevelt, said there are too many companies doing things. There was no federal regulation at all. It was just state by state. So what you got was people going from one state to another, selling 100% of the company to me, and another 100% to you, and then another 100% to the guy down the block. And you can imagine what happens. They just jumped into their car or jumped on a horseback then, and off they were to another state, and they couldn't be touched because they hadn't done anything in that state. So Congress and the president signed into law the Securities Act, and since then there have been many updates and amendments and changes. So they also gave power to the SEC to create regulations. That's not the same thing as a law. Only Congress can create a law. But they said, okay, SEC, help us implement this. And if you have an idea within the powers we've given you to make things better or to create more opportunities, go ahead. So in about 1993, they started working on this. And in 94, the federal SEC said, we're going to create this regulation. We're putting it in place. It's Regulation CE, Rule 1001. And that includes the rules defining who can invest, how you can advertise to them, all these kinds of things. And they coined this term qualified purchaser, which will explain what that means and how much you can get as an investment from someone. And that's within the $1 million or $5 million caps that I've mentioned a couple of times. California passed its own laws and regulations, and we know it as the 25102N, or the California Loophole. So this is a cooperation, which doesn't always happen, but it's really good cooperation, in this case between California and the federal SEC, and any other state that chooses to get on board could do it, but we're focusing on California because it's the only place that exists where it exists today. So this is very important. There are a lot of terms people have heard or are going to hear, and I want people to understand what a qualified purchaser is. Now, there are several definitions that they're going to find if they look at the federal regulation or the California Corporations Code, meaning California law. But the key is when you're selling to the folks in California, here's what they're going to look for when they're talking about individuals. The person has a minimum, and I'm reading right from the code, has a minimum net worth of $250,000 and had, during the immediately preceding tax year, gross income in excess of $100,000 and reasonably expects gross income in excess of $100,000 during the current tax year. Now, that's one of the ways they're defined. Or number two, has a minimum net worth of $500,000. So there's a couple of ways you can do this. If an individual has a net worth, and if they're married, they count together. So if you have an individual or a couple that's worth $250,000, and I want to be clear here, there's no rule here that says, like at the federal level, that you can't count the net worth they have in their home, for example, or homes they own, or stock, or bond, or other investments. So a net worth of $250,000 and a gross income of at least $100,000 plus a penny, plus a dollar, plus something. So at least essentially $100,000 income. Do they qualify as a qualified purchaser? Yes. The other category for qualified purchaser is a simple net worth of $500,000 without any reference to income. So they're retired, they're not working, they're unemployed, they're not looking for work, they are working and they're making lots of money, a little money. All they have to have is a net worth of $500,000. Now, the third possibility is they're an accredited investor. Now, that's under the federal rule now. And very briefly, what that means is if an individual has an income of $200,000 a year and has had that for the past couple of years and expects it for this year, it's gross income, not net. So before taxes, they make $200,000 a year or more, they can invest. A couple that makes $300,000 a year or more gross before taxes, same thing, past 2 years and the current year is expected, they can play in this game. And then finally, an individual or a husband and wife, $1 million net worth, but they can't count the home they live in.
Okay,
so,
Ralph, I don't want to get off on that too much. The deal is here in California, it's qualified purchasers,
okay, so
accredited investors.
Understood.
And a qualified investor is just half a accredited investment.
So what I want to say, Alan, is the qualified purchasers, what they've done is they've defined it based on income or net worth. It's a very simple thing. Yes, if you're an accredited investor under the federal definition, you don't even have to you don't have to worry about if they're a qualified purchaser. But what they've done by doing this, Alan, is they opened up a whole flood of people who wouldn't count under other rules as accredited investors and said, look, you can have just a net worth of $500,000. Now, that's a lot of money. Not everybody has it, but a heck of a lot of people in California do. And you don't need to know what their income is. But let's say you meet someone and they're not worth $500,000, but they're worth $250,000. Then if they've got the gross income of at least $100,000 a year, they can participate too. So those are the two key definitions for qualified purchaser, and they can participate and invest in your business.
So it's either or.
Yes.
Not both, right?
No, and they don't have to meet both. So let's say you're giving people the pitch and you're going to give them information and they ask, well, can I participate? And the answer is, well, we have to check if you qualify as a qualified purchaser. And they would ask the same question people on this call would be asking, which is, what is a qualified purchaser? Just to wrap it up, if it's an individual or a couple, $250,000 net worth, including anything they own, and they have an income of at least gross $100,000, then they're set. Or, not and, or they have a net worth of $500,000. Then it doesn't matter if they have an income or if they have an income, what it is. It's that simple.
Okay, cool.
So they are qualified purchasers. Now, how do you prove it? You certainly don't have the right, because it's not legal, to demand someone's tax return. You give them a questionnaire, and there's lots of examples of them out there, but it's basically you need it in writing because you need the person or persons you're working with to put it in writing. So you could come up with a very simple questionnaire that simply says, okay, name, address, birth date, other, contact information. Okay, are you a qualified purchaser? There are two ways that you can be a qualified purchaser. So one, do you have a net worth of $500,000? If yes, please check here. Okay, if you don't, do you have a net worth of at least $250,000? And if they check yes, then you have a follow-up question. Do you have a gross income of at least $100,000 or more every year? Is that what you're going to make this year? And if they answer yes, they are. Now, how do you prove it? You don't get to ask for tax returns because that's not legal.
Well, yeah, you're done at that point.
At that point, the rule is it has to be reasonable. And the basic way you know if it's reasonable or not is, look, if they tell you they've never worked in their life, they've never won the lottery, their spouse hasn't worked, in other words, if there's no basis whatsoever to see how they possibly could be worth $250,000 or $500,000.
Yeah, but once they answer the questionnaire, you're done.
Right. But as long as they fill that out and then they sign it, you're allowed to believe them. Now, if they tell you, look, I'm lying to you or something blatant, no, you shouldn't take money from them. And yes, let's warn people. Sometimes people will either not understand, they'll make a mistake, or they'll flat out lie. It doesn't happen very much. It's not your fault if they do that. The goal is simply to give them the questionnaire and say, look, I'm not going to put any pressure on you. I just want you to answer these questions honestly. And if they aren't able to participate, then what I suggest you do is, first of all, don't put them into this offering because that'll break the opportunity you have. It's called tainting because you'd have someone who doesn't qualify, and it's strictly for, so one of the questions you're going to ask is, are you a resident of California? And people will get residence based on, do they rent a home? Do they rent an apartment? Do they lease something? Do they own? These are all different ways they can qualify. But do they have a driver's license? Is California where they vote? In other words, all the typical things you think of as, how do you know someone lives in the state? Okay, so they reside in the state of California. Okay, now, do they have the net income? Do they have the net worth of $250,000 or $500,000? If it's the $250,000, do they have the income that's necessary? But if they don't qualify, respect them as you would anyone else and say, I want to keep in touch with you because there may be an opportunity that you're going to grow into being a qualified purchaser. Or I might do a different type of offering that doesn't require you to be a qualified purchaser. Or they might be an accredited investor and get confused and think, but I'm not a qualified purchaser. The point is that an opportunity may open up in the future, Alan, and you always want to take advantage of the effort and time and resources you put into getting that contact, treat them with respect and say, I can't have you involved right now because it's not me. The SEC won't let it happen, and we have to follow the SEC guidelines. But I'd like to stay in touch with you. So if you do emails or you're going to do some other way of doing a newsletter, for example, however you're going to stay in touch with people, don't waste the opportunity to add them to the database of people you've met and know, build the relationship. And, not everyone is permanently, you're not born a qualified purchaser. You don't have a guarantee of permanently remaining one. People may become one year, and a few years later they lose their job or they've lost some money on investments. They may not be a qualified purchaser in 5 years. On the other hand, somebody might just graduate high school or college, and in a few years they're going to become a qualified purchaser. Don't throw away the opportunity to work with them in the future. Hold on to that contact, treat it with loving kindness, and then they grow to be one of your investors in the future.
Let's just boil this down. The deal is you're looking for money.
Yeah.
Somebody raises their hand. They live in California. You send them a little questionnaire. They check the box. If they qualify, you can borrow money from them.
Absolutely.
Okay, let's move on.
Okay. So the 5 steps to implement this opportunity. You have to have a company. Now, you must do it as a business, meaning no DBA, no sole entrepreneurship, anything like that. You have to have either an LLC or a corporation. So you see the word foreign there, that's going to throw some people off. A foreign corporation, this is for everybody outside of California. If you don't live in and have a company in California already, an LLC or a corporation, you are quote-unquote foreign. No, it doesn't mean you came from another country. It means you're coming from another state. So any of the other states in the U.S. So the point is you have to have a corporation or an LLC. So if you come in as a foreign company, what that means is you're going to take your company's paperwork from your state where you're doing business, where you're headquartered, and you have to get it certified. That's something the state does. So the corporation's office in the state where your business is registered, Alan, will say, we certify that this company is in good standing and is either A, an LLC, or B, a corporation in the state of Delaware, the state of Nebraska, New Jersey, any of the other states.
Yeah, so when you incorporate, what they do is they send your certificate, and that's what you're talking about, right?
But
okay,
you're
cool.
going to have to get what's called a certificate of good standing. So if your company's brand new within the past 60 days, you don't need a certificate of good standing. But if you've been in business for more than 2 months, then you're going to get what's called a certificate of good standing, where the state says, yes, they've paid all their filing fees, and there's no trouble with their paperwork. They're good with us. And that's going to go to the Department of Corporations in California, and that's all in the paperwork that you're going to file with the state. And so how do you do it? Well, there is a package of information that's printed up, or you can print up, that is from the state of California. And one of the forms they have is, it explains how you do it. But the summary is you're going to get that certificate of good standing, and you're going to include it in your paperwork. Now, where you send it is the California Department of Corporations. And in fact, California is such a big state that they have 4 different offices for this up and down the state. Now, I'm going to suggest that, and this is what I always tell the people who work with me, because I'm allowed to do this to help them, Sacramento is the state capital. That's where all the paperwork ends up. So if you file in Los Angeles, San Diego, or San Francisco, you're just adding a day or two to how long it takes to get this done. So why not file directly in Sacramento? So if people want to know where to file, now you're going to have to get the paperwork first, but it's going to go to the Department of Corporations, 1515K, as in King Street, Suite 200, Sacramento, California, 95814. That's where it's going to go. So there's nobody's name you put on it, just the Department of Corporations.
Hey, Ralph, can we back up here just a second? Because you told me something. Now, when we file as a foreign corporation, I live in Ohio, so I don't look for that paperwork here. I go to California, and they've got you ask for them to mail you a package, or
you can download it.
Download it? Okay.
If you go to the Department of Corporations website, they have a page with nothing but forms. And so what you want to look for is, you're going to see you have choices. You can pick different pieces of the package. I suggest you pick the one that says complete package for 25. Again, we call it the loophole, but what they call it is Corporations Code Section 25102, and then in parentheses the small letter N for Nancy, 25102N. You select and download and print the complete filing package. It will have directions, it'll have instructions, it will have definitions, it will tell you what address, where to send it, what are you going to include. You're going to be including the form itself, and I have that in front of me, and it's just a couple of pages of questions about, what is the name of the company, where is it located, can you tell us, please, a little bit of information about who owns it and who's going to be doing the business. You're also going to include, some people will call it a business plan. I call it a disclosure document. You have to include a copy of what you're going to be giving to inform people about the risks and benefits of what you're doing. So that's called an offering. Some people will call it a business plan. You also have to have include language that tells people this is only for residents of California, so that if somehow someone gets a hold of it, and yes, you can advertise, including having a website, but the website has to tell people, as does any other kind of advertising, only for residents of California. And I would suggest that you also add only for qualified purchasers and accredited investors who are residents of California. But some very simple language that makes that clear, so if someone accidentally gets a hold of it in another state, they don't mistakenly think they can participate. And so when you talk to people, of course, one of the things you're going to ask is, are you a resident of California? You also need to fill out, and you'll see when you download the package, something called a consent to service of process. Now, what that simply means is, in addition to if there's ever, we hope not, but if there's ever a lawsuit, you're giving the California Department of Corporations the power to sign on behalf of your company. But that also means if the state government of California creates a new law or a new regulation or something that's going to impact your company, they will typically mail a copy to every company that's listed doing one of these types of offerings, and they know how to reach you. You should include the $600 check made out to California or CA Department of Corporations. Can it be rejected? Yes. What is the basis for it being rejected? You don't actually have a California registered, or qualified company, meaning you don't have an LLC, or you don't have a corporation in California, or you haven't registered to qualify it as a foreign corporation or foreign LLC, or you haven't filled out the paperwork right. But what they don't do is go through it and do an evaluation of, do we think this is a good investment idea? So they're never going to tell people, yes, you should, or no, you shouldn't participate in someone's offering. They'll simply say, yes, they're registered with us, or no, they're not. So the only way to get rejected is you didn't get your company qualified to do business before you sent in the application form, in which case they won't cancel it. They'll simply say, please get your qualification for your company in, then we can go ahead and let it go through. Or you didn't fill out all the forms, you didn't include copies of your advertising or something like that, and they'll say, well, we'll hold it. But if you continue to not provide what they ask you to provide, ultimately they could reject it. I've never seen that happen. Virtually happens never, because unless you simply want to mess up your filing, there is no evaluation of the offering itself. So as long as you've filled out the forms, signed everything properly, you'll notice that there is one page that has to be notarized. And as long as you get that all filled out properly and filed, and you pay them the check for $600, they can't reject you. Does that make sense?
Yep.
So now, the 25102N form, the loophole form, it is not hard to fill out. You are not required to have an attorney. Any attorney in any state theoretically can help, and let me explain why. Because there is a federal piece of this, and that's called Form D. I want to be very clear. Technically, they don't even require you to file Form D, but I always suggest it because, A, it shows that you are demonstrating that you're going to comply with the federal rules, and B, it creates a free advertising opportunity. And what that means is every Form D that gets filed, and there's no filing fee for it, it gets filed with the federal SEC, goes into a database that's public and free for everyone to find. And over the years, I have had clients of mine who've been listed by filing the Form D for the California loophole. People make a business of going in and looking at it every day, and they're looking for investment opportunities. Now, you're the investor, but they're looking for an opportunity to put money into a company, and they might say, I'm looking for somebody who's doing real estate in California because I don't want to start my own company to do that. I want to find somebody who's doing it the right way. So if they find your Form D and look it up online for free and contact you and say, hey, I want to learn what your company's doing, you can send off your packet to them, and they may put money into your company. So, again, pardon me. Again, it is not legally required to have an attorney. I do suggest that it might be helpful to have one at least review this and give you some guidance on it, because there's the federal component on it, but you are not required to have an attorney to fill it out or to file it. In fact, one thing I'll give people a heads up, Alan, the instructions are close to 10 pages. The form is 2 pages. Don't let that overwhelm you. They're just doing their job, disclosing all the rules, all the regulations. They give you basically a copy of the definitions. So you'll find yourself going through it and saying, wait a minute, where's the form? Where's the form? And then you get to, and this is important, I want people to understand it. You're going to see 2 things that they call notices. And I'm holding in my hands right now, first notice of transaction, 2 pages. What else goes with it? Consent to service of process. That's it. Now, there's a quirk to this, but when you file 3 pages of forms, what do they ask? Name of issuer, very important. It's always your company, not your name, not your spouse's name. Things like, what's your telephone number? What type of filing are you doing? Are you going to give people copies of the disclosure statement now or later? Are you going to do advertising? Okay, yes. Please give us copies of your advertising. Do you promise to do this under the law? Then consent to service of process. Do you agree that you're going to sign for documents that are filed by the state, or if there's a lawsuit? And if you don't, we'll sign for you. Do you agree to that? Yes. That's all the state asks for in terms of paperwork. Now, within 210 days, and it's an odd number.
All right, on this, a couple things. On that 10-page to-do list, do they put on there to fill out the Form D?
No.
No. Okay, so
I'm suggesting it.
You're suggesting that. So that's not a must-do. That's a nice thing to do.
I think it's a benefit, but it is not a requirement.
Yeah, very good point. It's a gold nugget here that you're giving my students that would help them out.
It's an advantage, frankly, because if you don't do it, you're wasting an opportunity to do 2 things. Show extra compliance, meaning you're doing above and beyond, because you're not disclosing any information that isn't going to be told to people anyways when you're asking them to put money into with your company. And it's free. Think of it as this way: free federal advertising that's legal.
Mm-hmm.
Right. Now, again, only people in California can put money into your deal. But now anybody in California who finds this by going that route can invest in your, as long as they're qualified purchaser or accredited, they can put money into your company. So why not take advantage of it is my viewpoint. And it's a very simple form. And if you have an SEC attorney like me, whether it's me or someone else, the point is he or she should do it for you for very little or for free, simply because it is such an easy thing to do. But I want to be honest, it is not required.
Not required, but it's a federal form, so you don't file it in California. You file it with the federal government.
That's correct.
Yes. Okay, another thing, second item. You tossed out a little phrase here called consent to service.
Yes.
Did you define that?
That's a good question, Alan. It's a legal term, consent to service of process. The consent to service of process form is in the packet they'll download from the Department of Corporations website. So it's a 1-page form that simply asks for permission that says, okay, either you're going to sign, meaning you are going to sign for your company when you're doing this deal, or we in California will sign for you if A, somebody sues your company, or B, we have an update for you on the law or regulation. So basically what it means is You agree that you're going to stay in communications with us, and if we have trouble getting you to sign for something, you've authorized us as a state, as a department of the state, to sign on your behalf. So you're always going to be in touch one way or another. That's all it means.
Okay, great. Thanks.
So that is the third page of the first notice that it's called. Now, there are two notices that you're going to be paying $600, and I'll get to the second notice in a moment, but the check gets made payable to, it's a lot of words, so you can shorten them, abbreviate, California Department of Corporations. So usually you'll see CA, space, DEPT, and then of Corp. Something like that makes it clear. That's who takes the payment on behalf of the state of California. Do you include your advertising? Absolutely. And the red flags are things that I think people will see as pretty straightforward. You're not legally allowed to do what the government does, which is tax people to make sure that if you can't pay for something, well, we'll tax Americans or we'll tax people here or there, or we'll put a sales tax. So what happens? You can't guarantee the results. You can indicate we promise to use our best efforts. You can't say no risk or low risk because the regulators will look at that and say, well, compared to what? Now, if you compare this, and you may, to, let's say, a CD or a bank investment or something like that, then all you got to do is say, you got to make sure in your disclaimer, when you tell people this is just for residents of California and that sort of thing, that you're not offering FDIC-insured investment products because you're not a bank. So you include your advertising, and the question that always comes up is, well, what if I come up with something new a few months down the road? Send it to the Department of Corporations at least 5 days. They prefer 10, but at least 5 days before you start using it. And why do they want it? A, they're going to put it in their file, and B, they're just going to take a quick look to make sure you haven't put guaranteed, no risk, or something that would otherwise mess it up. So the key is don't mislead people. Don't cause them to think you're going to do something you aren't or misinform them. Now, can you do newspaper ads? Absolutely, you may. Just remember, California is a big state, so the LA Times is probably not going to cover you very well in San Francisco, and the San Francisco paper won't cover you in San Jose. So you want to target radio and TV. Absolutely, you cannot. Now, Craigslist, your own website, you may. And the key is whether you're doing a newspaper ad or something on a website, you have to put disclaimers that tell people this is only for residents of California, for qualified purchasers and accredited investors, things like that. And as long as you put that information, you're okay. But they've made a decision, and it's ironclad, no radio and TV, and as it's been explained to me, California is simply too big a state with too big a media market that you could easily spend $5 million in advertising to raise $5 million. So it wouldn't be very effective, and they don't want you using investors, your own money as an investor to do it, and they certainly don't want you using your private lenders or private people who are bringing in money. You can't touch their money to do it. So newspaper ads, flyers, postcards, things like that, absolutely okay. Craigslist, actually you may, because you're allowed to use a website. And in fact, you'll see on the 2-page form when you're filing, they'll ask you, do you intend on using a website or websites? If so, what would they be? So you would list Craigslist if you're planning on it, and any other of these other websites that are either free, or let's say you're going to do a Google ad words, or Yahoo or Bing, all the different competitors out there. I'm not preferring one over the other. Just list what you're thinking of using, and if you have your own website, great, let them know. Why? Because they just want to make sure to check it and make sure you're not misleading people. And as long as you're not misleading people, They're not there to judge if it's going to be effective or not. They just want to make sure that you don't cause problems or mislead anybody in their state.
Yeah,
That's what they care about. They want to protect people.
Hey,
Yep.
on the advertising, I heard you say something about, I thought, what some things you would want in the ad. Is there some things on the list of to-dos that they give you, or that 10-page thing, or how did you know what you need to put in the ad?
They actually do give some suggestions, and you will sometimes find they don't always, it's odd, they don't always have it posted. They used to put up what they had was a sample postcard to give an example of the contents, because it wasn't just for a postcard, but, for example, a lot of people, they've told me when I've talked to the staff attorneys, a newspaper ad that is about the size of a postcard is very affordable in most newspapers as opposed to a half page or full page. And so the kind of things they suggest that are certainly allowed to be used will be language along the lines of real estate investment, $5 million raise, the name of the company that's making the offering. And here's a very important point. If you're raising up to $1 million, there are two ways you can get the money from people. One is a traditional promissory note, or you can sell people stock in your company. If you're going to go from 1 million and one up to 5 million, you have to sell people stock. And so what they suggest is you have 5 million shares in the company, at least, that you're going to sell to people, and that each one is priced at $1. So if someone wants to invest, wants to put $10,000 into the company, then you're selling them 10,000 shares of your company. It's a twist because for some reason, that's what California decided to do as opposed to promissory notes.
Okay, but what does that have to do with the ad? I'm not connecting.
Because you would tell people, instead of saying, if you were going to put it in your ad, invest using a promissory note, you could, if you chose to, tell them, buy shares in my company. You don't have to say that. So what I'm telling you is, if you don't find it on their website, then it won't be, there's no list that's put out that says, here are the things on the website. But what you will find in the pages of instructions that you get in those 10 pages we talked about from California, they'll tell you the kind of things you can include and that you may not. So they won't write the ad for you, but they spell out paragraph by paragraph, here's what is allowed, here's what we want you to at least include, and here are things we don't want you to ever use.
Great.
So they'll walk you through it.
What you do with some of my students is, not on this, but on other things, is you'll say that you got to say in your ad, like, this is not a public offering, that, okay?
Right.
Is that one of the requirements here?
Yes, but in fact, this is a public offering, so normally what the disclaimer would read would be along the lines of this. This is a public offering available only to residents of California. You must be either a qualified purchaser or accredited investor. The offering will only be made available after you have had at least 5 days to read our disclosure material, and that's one of the requirements. You have to give people 5 days before you take their check. So you meet them on Monday, then 5 days later, you could take their money. You can't take their money the next day or the day after that. So you have to give them 5 days. And then you can say something along the lines of, let's say you're comparing it to a bank or a CD product. Money is not FDIC insured.
Got it. Okay.
Keep it very simple, short sentences.
Yeah, good information. Thank you. All right.
Sure. Now,
lead right into this.
The disclosure statement it's your selling document. Again, some people like to call it a business plan, and that's absolutely okay. In other words, it's not a formality where you must call it a disclosure statement. Let me go back to that slide. But you do have to include it with your filing. If you don't, they won't approve it, meaning they won't let you proceed and this is an important thing, they don't always acknowledge your filing. So I'm going to suggest when you file, send it where there's some proof of delivery. I do not suggest that you make them sign for it because they're very busy. They do a lot of stuff. They're not just doing these. They're doing every kind of security thing you can think of in California, and it's a very big state. So they really don't like having to sign for each letter they get. But use a company, whether it's the post office or a private company like FedEx or UPS, that can give you proof that it was delivered on a certain day, and that way you can always demonstrate, yeah, I did file with your office, and here's the proof from a third party. So you're going to include your disclosure statement when you file the first notice. And that should include all the basics: who, what, where, when, and how. So who, it's your company. It's not you personally. What are you doing? We're investing in real estate in Minnesota, in Nebraska, in Massachusetts. Is it residential? Is it commercial? Is it this? Is it that? Are you going to buy and hold? Are you going to flip? Are you wholesaling? What are you doing? Okay, where are you doing it? Is it a certain geographical location, or are you crossing state lines?
Hey, Ralph?
Yep.
Rather than getting too deep into this, every state requires that folks that borrow money from private lenders have to have a disclosure, yes?
Yes.
Okay, so here, in this case, someone from Utah is getting ready to use this California loophole, as I call it.
Yes,
they just got to attach your disclosure and send it in.
Yes, just a very basic disclosure of what you're doing and how you're going to do it. Yep. And you have to include a statement along the lines of, we can't guarantee results. You may lose some or all of your money. That's expected. Okay. Where does all this go? It's going to go to the California Department of Corporations, and I suggest it goes to that address in Sacramento that I mentioned earlier, 1515 K Street, Suite 200, Sacramento, CA 95814, because that's where all the things end up from their other 3 satellite offices, and that's their state capital, so that will get you through the fastest. How long does this take? Once they've received it, and as long as your check doesn't bounce and you've included everything you need upon receipt, it is good. Now, the only thing I need to warn people is California, like many states, has had some budget problems. If you are going to create a California corporation, they can take longer than they used to. How long? It's important that you check either using a service company. If people hire me as an attorney to help them form the company, I always inquire directly or through a service company, how long is California taking? Because don't be scared, but earlier this year, their Department of Corporations literally was out of money, and it was taking 8 weeks to get filings done. Not the form being filed, but filing a company, a new one in California. They got a budget injection from the legislature, so they're fine. But the bottom line is always check how long it's going to take them. But when you file your first notice, as long as you've included everything, including the check, it's automatically accepted. So that's why you want the proof of delivery. So you can start advertising the same day you file, as long as you put your ducks in a row, and 5 days later, you could start taking checks. Now, the second filing, it's not 9 months. I should have corrected that. I apologize. It's technically 210 days. There is no cost for it. The only reason they've given me is why is, and it's a very short form. I'm going to pull it up right now. They consider it to be a census form, because what they told me is, and it's called the second notice. It's 2 pages. It's the same information about what you've done and what they wanted to know, and here's the key to it all. There's a question on page 1, question 5, date of close or abandonment of the offering. What they want to know is, did you give up because for whatever reason you couldn't or didn't or stopped raising money, or have you already raised everything you were looking for, let's say the $5 million, and if not, then you say not closed. So what they're really trying to do is build a database, they've told me, of how effective people are, meaning their companies, in raising money in the state. And by having this filing done, they can build up over the years, and they have an idea of how successful people, their companies are in raising money using this type of offering over what time period. That's why. There's no cost. It would be filed with the same office, the same address in Sacramento.
Hey, Ralph, a couple questions on that. One is you have to file the second notice prior to 100 or 210 days.
Right.
So
Which
you aren't going to send it out like the next month. So you want it to, I guess, when you file.
No, I suggest you wait roughly 6 months, which is 180 days, and you might be done by then. It's very possible you've raised all. Maybe you're not raising $5 million, or it's gone really well and you've raised the $5 million.
Okay.
But yes, I would suggest 6 months is reasonable.
All right. Second question is, I get questions from my students that do you need to file every year?
Yes,
something?
Every year you have to file the first notice again, the $600. But remember, you're talking about every year raising up to another $5 million. So yes, you are going to have the $600 cost every year.
Got it.
The second notice, no cost every year unless they change that, but they have no plans to. And you want to keep your company in good standing and qualified to do business. But
another way to look at it is you're filing every 6 months something.
Yes,
and
you're absolutely right. That's a great viewpoint. Every 6 months, like clockwork. Your first notice, your second notice, your first notice, your second notice.
Yep.
And now someday you may choose to stop raising money, but then you don't have a filing. But otherwise, every 6 months you're doing a filing, but only every 12 months are you paying for it, Alan.
Yep, I got it. All right, let's go on.
So who can't use this? Well, if you've been convicted of a crime of fraud, particularly at the federal level or state, whether it's for securities or something else, if you have a felony conviction, you cannot participate. They will not let you. Otherwise, as long as you have a company in good standing somewhere, whether it's California or you're bringing in a company from another state, and they do prefer that it be a U.S. company, theoretically they will take foreign companies, meaning from another country. But if you're coming in from another state or another country, you need to have your company qualified to do business. So if you fail to do that, you can't participate. If you've been convicted of one of the crimes I talked about, you can't participate. If you have a cease and desist, you may participate, but you have to tell the state of California to the department in your filing and in your disclosure that you have a cease and desist, what state or government you got it from, what happened, and what you did promise to do or not do in the future. So let's say you tripped up, you got a cease and desist because you did you did something without a proper filing, and they said, okay, you can go raise money in the future, but let people know that your company has a cease and desist, but we didn't convict you or charge you, if anything, but you agreed to always comply with securities laws. That's all you'd have to tell them because it's the truth. But you can still do it. Your company has to be in good standing. But essentially, as long as you're living and breathing, your company's in good standing, and you haven't been convicted of a felony, you can do it.
All right.
So, unlimited number of qualified purchasers, absolutely. And unlimited number of sales to California residents, absolutely. The only thing that might apply, and if you get even close to 2,000, I'd be amazed, frankly. Under the new Jobs Act, the SEC said small companies that haven't gone public yet can have up to 2,000 private lenders or private investors, depending on how you want to define them. So the only limit that theoretically would be applied would be the 2,000, but that's at the federal level. And since this is technically a state filing, yeah, if you can figure out a way to manage your business and deal with more than 2,000 private lenders, well, congratulations. And second, it's going to be a challenge. But yes, that's how the law reads and how the regulations.
Using my systems, they won't need that. They won't
right.
get that many. But if they could have like one person give them $5 million.
Oh, and I've never heard of that happening, but I have heard of cases where you can get a small group of 5, 10, 20 people, or you'll get some investment funds that they're actually registered as like a private equity or hedge fund, and you absolutely can take money from them. So they might write you a check for $500,000 or $1 million.
Mm-hmm.
So does that count against the cap of $5 million? Sure, it does. But yes, you put it out. 5 days later, you get a check for $5 million. It clears. You're done raising money for that year. So 6 months later, you file and you say, when did you close it? Well, 5 days after we opened, we closed the fund because we were capped at $5 million.
Yep.
Is it likely? No, but it might happen. If you borrow money from folks in California and you use it in the state you live in, yeah, you can do that. Now, could you raise money on top of that from California, not under this offering? So what that would mean is you have a corporation, because you need a corporation, remember, to raise the $5 million. So Allen's Corporation Incorporated raises $5 million over the first 6 or 12 months. It cannot do any more using this offering. 6 months after it raises this money, it theoretically could, but here's the problem. You could use your corporation to raise more money, but you'd still be capped out at $5 million, meaning it's called integration, and the state would say to you, the most you can raise in our state is $5 million in a year. So no, unfortunately, if $5 million isn't enough for you, you'd have to look at starting another corporation and going through the same process and doing a filing, and then you still have to keep the money separate, but you could use those companies to both invest in a project. So let's say you have a project that needs $10 million. Company A raises 5 and owns half the project. Company B raises 5, owns the other half. That's okay. But you can't raise more than 5 with a single company in a year in California.
Where I get into questions with my students, Ralph, is, for an example, in most states you can borrow $1 million from family, friends, and associates, except for a couple states.
Right.
And so what they ask me is, hey, can I use the family, friends, and associate and for $1 million in my state, and then go get $5 million out of California and use it in my state? That'd be $6 million. You're saying no to that,
no,
right?
Because California does what's called integration, and it counts every dollar that company raises anywhere in the country against the 5. So if you only raise 4 in California and raise another $1 million in your home state, that'd be okay as far as California is concerned.
Yeah, they're trying to get higher. So you can combine it. You max out at $5 million.
That's correct. So if you want to go above $5 million, there are other solutions, but not this one.
Got it. Okay, cool.
So if you borrow money from folks in California, can you use it in a state other than the one you live in? Yeah, and the way that would work is, remember, the only state that asks you to let them know if you're buying some property that someone could live in, residential property, New York State says we want to know if you're buying residential property that you aren't going to live in yourself. But every other state says if you raise money here, we want to know about it. But otherwise, just pay your taxes and do what you have to do and clear your title and so on. So let's say you live in Massachusetts, but you want to put the money into use in Rhode Island. That's not a problem. You want to tell people that in your disclosure so California will know it because they get a copy of it. Your private lenders will know it because you've told them. And as far as Rhode Island is concerned, just follow the laws of Rhode Island in terms of buying real estate and doing whatever you have to do in terms of complying with real estate and taxes and so on. But as far as California is concerned, they have no trouble with it, and the SEC has no trouble with it at the federal level because you've complied with their rules in terms of raising the money. Then they're absolutely fine that you've done it. But again, at that point, there's no question in my mind you want to do a Form D filing, and without dragging it out, it's simply because when your money crosses state lines, typically it's because you've taken it out of California. The SEC wants to know about it. They certainly want to know if you take it out of California, bring it into your home state, and use it in a third state, that's crossing state lines. That's interstate commerce. They have a fundamental demand that they want to know about it. Now, it doesn't cost anything to file the Form D. It's just informing them of it. You're going to be covered, and you're technically registered with the SEC, and it'll look good for your business. But at that point, you absolutely, in my opinion, want to.
Yeah, that's a great point. Now, this is our last slide, and just to kind of give an overview of this thing is here I live in Ohio. What I could do is I could go through the steps you talked about, filing California. Goal is to bring money out of California from folks that live in California. I can use it in my state. I can use it in your state where you live. You're in a different state than me. And, I could take, $5 million out of California and use $500,000 of it in 10 different states, and everything is good. And now, question on that. On the, I do the Form D, and then do I need to notify those other states or anything, because they're there to protect their private lenders, and so I'm not borrowing in those states.
That's correct, and that's why you might have zoning laws to comply with, and clearing title and title insurance, and all the other stuff that you would do involved in buying and selling real estate. But no, securities laws kick in, except in New York State. When in New York State alone, when you buy residential real estate that you won't live in, but your company's buying, you must tell them, and that's part of the New York State Attorney General's office. They have a Department of Real Estate. There's a form you fill out. There's a small filing fee, but that's the only state that requires it. Other than that, every state simply says, well, follow our laws for doing business in our state. But as far as they're concerned, if you're not borrowing money from residents of their state, you're only borrowing money from residents of California, and you're complying with what they want by filling out the first and second notices, then no, the other states, except from New York, they don't consider you doing securities work, so there's no securities filing to do.
Got it. Okay. So, it sounds fairly simple, not a lot of cost, and the key to the whole thing is convincing folks in California to loan money used in another state.
Absolutely. I mean, I want to say very quickly, I think it's a tremendous opportunity. As an attorney, I may have made it sound at times a little more complex than it actually is. It really, you're going to be amazed when you look at the forms you download and how many instruction pages there are. And there's 3 pages for the first filing, and there's 2 for the second, and it's $600 a year and 2 filings a year. And then the only other one is that free filing with the federal SEC, the Form D. You don't have to use an attorney. I suggest you think about it, but the point is, it's not the Attorney Employment Act. This is a great business opportunity for you, and it actually is as straightforward as it sounds. I've worked with your students from Canada and from a whole bunch of U.S. states, and they have gone in to raise money for commercial and for residential in other states. I haven't yet seen any of them raise money to put into another country, but even that theoretically would be okay, at least as far as California and the SEC is concerned. So it is the one chance you have from one state to raise $5 million and advertise and pool the money.
Great. Oh, powerful. Well, I'll tell you what, I thought I knew a lot before I got on this training, and I even learned a ton going through it. So there's a few things that you taught me I didn't know about that.
I'm so glad, Alan.
Yeah.
I'm so glad to share this information with your students. I'm honored to participate in it.
Well, thank you very much. I appreciate that, and this has been great. Thank you very much.